ministers in the temple of justice.
For anyone on the bench of the Nigerian judiciary, this chamber is the ultimate.
Let us all strive to maintain the independence of the judiciary so as to ensure the rule of law.
And the fact that the ministry is responsible for prosecution of cases makes the ministry very visible naturally.
If it is to buy time, you know who is buying time.
Becoming the first woman in the country to discharge the function. To me, Allah wished it that way.
Welcome to the program, The Scale of Justice.
Tune in every Monday at 2:05 p.m. and repeat broadcast comes up every Wednesday at 6:30 a.m. on the network service of the NTA. Keep a date with us.
When an assignment is given, one of the expectations in carrying out that assignment is for an update to be given as to how far that assignment has been carried out and how successful it is. Does it meet the expectation of the people who have given the assignment? That is what the Presidential Committee on the Reform and Decongestion of our correctional centers has been doing in recent days. The chairman of the committee has been given an update of how far the job has been done in reforming and decongesting our correctional centers. That is going to be our focus on the scale today. It is to help us know how successful we are in tackling the problem of awaiting trials in our correctional centers and generally our criminal justice system. Welcome to the program. I am Femi Okeowo. Even though the Nigerian correctional centers are under the Ministry of Interior, the Presidential Committee on the Reform and Decongestion of the Centers is under the supervision of the Ministry of Justice. And so, in giving an update of how far the job has been done, the Minister of Justice, Abubakar Malami, Senior Advocate of Nigeria, joined the chairman of the committee, Justice Ishaq Bello, in the briefing. And so, let us hear what the two of them have to say as to how far this job has been done and how useful it is, both in terms of legislative and executive changes for Nigeria. Let's go into the briefing. On the 1st of June 2017, Nigeria's Federal Executive Council directed the creation of a special presidential committee to decongest and reform the nation's prisons, as it was then known. This committee was inaugurated on the 17th of October 2017 under the chairmanship of the Chief Judge of the FCT High Court, Justice Ishaq Bello. And so now, for the last 3 years, the committee has gone around 18 states of the Federation, visited 39 correctional centers, and released 7,813 inmates.
The decision is that you should be discharged, having observed more than substantial period of the imprisonment. So you are going home today. We have declared the High Court Kuje as the Criminal Trial Division so that nobody will suffer not being taken to court because of lack of transportation.
Both the minister and the chairman of the presidential committee said in view of their importance to the nation's future, juveniles in the nation's criminal justice system need to be particularly cared for through a comprehensive master plan which is about to be rolled out.
Anytime I'm talking about this set of people that are behind the correctional service centers, I sympathize greatly to the management of the various centers, because these inmates represent a very difficult segment of inmates to deal with, to manage. Apart from the paucity of drugs, even the little that could be assessed are very difficult to dispense, to administer, because for them to even take the drug is a Herculean task. And some of them, even to maintain hygiene with them, is posing a lot of difficulties to the management of the correctional service centers. I see the difficulties they have. And there are no such type of group of segments behind bars that you can say, release them to go home. Some of them don't even know where they are from. They don't even have relations that you can entrust them to. And asking them to go to the street is like setting them against the background of so many ills that are happening in terms of rituals, killing, and what have you. So we were very circumspective. We declined releasing them to the dismay and sadness of the management of the correctional service centers. We see this visibly on their faces, but there's nothing we can do but to exhibit that maturity by restraining ourselves from asking them to go into the street of the society, exposing them to the dangers that might be visited on them. In Ogun State, a particular woman who had completed her 5-year sentence but was still incarcerated for her inability to pay 1 million naira compensation sum was also released. And the committee recommended that rather than incarcerating an offender solely for inability to pay compensation, a competent court of jurisdiction should decide on payment plan or sentence in lieu of. In fact, we frown against this, because I repeatedly said wherever we found this kind of situation, that compensation is like judgment sum. It can be enforced like that judgment sum. You can't ad infinitum order anybody to remain behind bars because of compensation. That means there is no definite date. It's as good as saying that he has been condemned to death, sentenced to life imprisonment. It's inappropriate. I have said this as we get along the visitation all over the country. It is all over actually. River State, as at the time of visit, majority of the condemned convicts were found to be from other states, and the committee invited the appropriate state executives to take the required steps to consider them for clemency, commuting their sentences to life or transfer to their proper jurisdictions. Not only that, we express our concern as to the number of condemned inmates who are also constituting themselves as institutions within the confinement, and the need to take necessary action. It is by that prompting we are glad to say that the government responded accordingly, and today within the Correctional Service Act we have a clear and express provision that mandates the respective chief judges of various jurisdictions where the governors failed, neglected, or refused to take necessary decisions in respect of convicts. There's only one thing that can make people follow you in an exercise like this, and that is credibility of the intendment, the mandate, for them to follow you and use their own personal money to engage the process. We are grateful to various NGOs who went around with us for this purpose. Interestingly, we have even international organizations that have seen the beauty of this program, and they means no words in coming forth to indicate their interest to partner with the committee for the purpose of driving through the very intendment as underlining the setting up of the committee. Therefore, the intervention from these few, as mentioned, are highly appreciated. Many individuals with options of fines or compensation orders were released, and they were happily reunited with their families through the benevolence of such a group, and to which this committee is profoundly grateful. I must note that we have the UN representative here that which has sustained interest in this program. And that is to say that the program activities and the purpose of setting it up has gone beyond the confines of the Nigerian community. It is an international issue because of the interest shown by international interest. The UNICEF came in with all its might, and I think in the next 2 days we are going to engage in virtual discuss what is their interest. They are interested in juvenile justice, those that are behind bars. And what brought them is because of the beauty, all right, the sincerity of this, the mandate behind this committee. And we welcome them, we have embraced them, and we're already charting a course which will really impact profitably in our own society. If there is any reason for a judge to order the remand of a juvenile, he has no option because of the deficit in this structural arrangement, but to send to the correctional service centers where adults are taken. Why? Because in those days you have articulate social centers where you can even send them in for custody, because you don't want them to get into the confines, incarceration where adults are. But you can't find such arrangements now, even with the social service centers around today. Now, the master plan we have in the FCT is one, to have a very big land, and we have acquired already through the Minister of the Federal Capital, to have a sophisticated family court where you have within a window for reintegration. Reintegration not just between disputing husband and wife, but reintegration even between these young ones and their family members. These young ones are visibly seen, they are not hidden anywhere, they are seen under the bridges, already afflicted by drugs and other vices in the society, and that's not the place they should be. Now, alongside that family court, which of course, as I said, there will be the integration center, you have a psychotherapist there, counseling professionals that will counsel the parents and the young ones before bringing them together. And what will happen before coming to that stage is you also have a portion where you have children and young persons court, so that you even take them away from appearing in the adults court, where nevertheless they will mingle with hardened criminals that are coming on trial day by day. So once we're able to achieve that, then you have the Boston Institute also within the same premises, so that if there is need for order for detention from the children and young persons court, it's just across. All right, you have that. Now, above all, and most importantly, within the same platform, you have a standard rehabilitation center, whereby if a court, looking at the suspect as young as he is already engaged in drugs, you don't need to go further. During the course of my presentation of this report, you have heard when I made advocacy, we as the committee made advocacy for establishment of clinics very proximate to the correctional service centers, so that you can address a lot of the lapses that are there today. Now, for these young ones that you mop from under the bridge, or in the event they are arraigned for any misconduct, there's the rehabilitation within the same vicinity. They will get rehabilitated, and then thereafter, they will be taken before that integrating unit of the family court for their parents and them to sit down with the counselors, the psychotherapists, and then they are all advised accordingly on how they will handle these young boys and readmit them back respectively to their homes.
Given an update of the impact of the Presidential Committee on the nation's correctional and criminal justice system, Minister of Justice and Attorney General of the Federation said more fundamental are the recommendations of the committee, which have resulted in both legislative and executive interventions that have improved the nation's correctional and custodial systems.
In the course of this visit, the committee also encountered a startling number of convicts deemed as deserving consideration for the grant of presidential pardon. Based on the committee's report, the Office of the Attorney General made recommendations to the President for the reconstitution of the Presidential Advisory Committee on Prerogative of Mercy, which was thereafter inaugurated in August 2018. On the advice of the committee, this office has also written to several state executives, appealing to them to act on some special cases encountered during their state visits, either by exercising their powers of clemency in deserving cases or commuting to life sentence those condemned to death. The Honorable Attorney General of the Federation and Minister of Justice also initiated the presentation of memo to FEC on the need to digitalize the correctional centers as part of measures to aid the congestion. The Federal Executive Council in April 2019 granted approval for the award of a contract for the installation of the virtual automated case management system to fast-track the decongestion of correctional centers in Nigeria. When fully deployed, this system will integrate with the existing correctional information system with the ultimate aim of effecting a holistic improvement in the efficiency of the entire justice sector. At a recent retreat which held in Uyo, Akwa Ibom State in March 2020, this ministry, in collaboration with the committee and relevant stakeholders, worked assiduously on a proposed draft sentencing guidelines incorporating non-custodial measures for the effective implementation of the Nigeria Correctional Service Act 2019. I am hopeful that the Honorable Chief Judge of the FCT High Court will endorse the adoption of these guidelines in no distant future, and that other Chief Judges will adopt them. Nevertheless, the committee, in collaboration with Federal Ministry of Justice, initiated the upgrading of the Skill Acquisition Center of the new Kefi Correctional Center, Nasarawa State, in December 2019 as a first step towards attaining the objectives of the Act. This is a pilot project to be replicated in other custodial centers across the Federation. The project will enhance the focus on corrections and promotion of reformation, rehabilitation, and reintegration of offenders as provided by the Act. The COVID-19 pandemic has posed its own peculiar challenges in light of the worrisome and dilapidated state of our correctional centers nationwide. Without belaboring the fact, it is pertinent to note the inadequacy of our correctional centers facilities, which are currently operating at more than 150% of their capacity. I must, however, commend the Minister of Interior for driving federal government efforts to ameliorating this state of affairs through the ongoing construction of 3,000 capacity maximum security custodial centers in Karshi, Abuja, and in Jambuza, Kano. Furthermore, in light of the social distancing and preventive protocols designed to limit the spread of the coronavirus, critical stakeholders, including the Federal Ministry of Justice, the Ministry of Interior, the Presidential Committee on Correctional Service, and the Congestion, the Presidential Advisory Committee on Prerogative of Mercy, and some executives were galvanized to develop measures to overcome the challenges. The initiatives adopted have led to the release of about 3,789 inmates, and we intend to sustain this momentum. What we are witnessing here today relating to the improvement in the quality of services provided in the correctional service centers across the country was a product of recommendation of this committee that gave rise to the promulgation of the Nigerian Correctional Services Act. Arising from the experience, recommendations of the committee, as a government will consider the possibility of discussing the issue of juvenile before the Federal Executive Council, consider the possibility of working on the recommendations of the committee, coming up perhaps with enhanced legislations that will now stand the test of time, and then consider the current realities on the ground for the purpose of ensuring at the end of the day that we have enhanced services as it relates to juveniles. Again, if we consider the issue of juveniles of paramount consideration within the context of constitutional amendment, it may as well perhaps be considered within that context. So what I'm trying to say in essence is the committee is indeed a blessing. Its recommendations as they arise are being factored into legal framework by way of legislations. Its recommendations are indeed being put into implementation and execution, and then we are now eventually seeing the gains associated with that experience, relating to the services and indeed recommendations of the committee. So we shall now, in essence, consider the recommendations of the committee within that context to come up with a suitable, perhaps, amendment to the existing legislations, or perhaps new legislations that will now see to it that the circumstances associated with juveniles are indeed adequately addressed as well.
The success recorded should encourage the team spirit and unrelenting efforts of all stakeholders and reform champions for the realization of the dream for a new order of correctional services in Nigeria. What you can see is the passion meeting the passion between the Attorney General and the CJ. Passion meeting with vision, passion meeting with discretion to ensure that they have started well, that they are not leaving the situation the way they are living. This is what two of you represent.
We have used this program to look into the activities of the Special Presidential Committee to reform our correctional centers. And you would have noticed, of course, you heard from the speeches, that in the last few months, a number of changes have been undertaken. One of them is the change of name itself, which is, we used to know them as the Nigerian Prison Service. Now it is known as the Nigerian Correctional Centers. And that is a very fundamental change, which helps to change the psyche of those who go into those centers. Thank you for being part of the program today. More issues keep being unraveled on a daily basis in the justice sector, and you can be sure that the scale will be on top of them. We'll see you again.